Mr. Chair, members of the committee, thank you for your time today. For the record, Senator Brad Hudson, representing District 33, which includes Stone, Taney, Douglas, Ozark, Texas, Howell, and Shannon counties. I'm here to present to you two very important Senate bills that are critical for the protection of children in Missouri. That would be Senate Bills 589 and Senate Bill 590. I will introduce these bills, but it is my intention to keep my comments as brief as possible so that I can allow time for you to hear the powerful witnesses and experts who've traveled to join us to share their stories and to provide testimony. First, Senate Bill 589. This is a critical piece of legislation for Missouri's children that eliminates the statute of limitations for civil cases related to child sexual abuse. The current statute of limitations in Missouri requires that child sexual abuse survivors file their cases by age 31, if against the person who abused them, and by age 26, if the case is against an institution that facilitated their abuse. A rigorous body of evidence shows that survivors of child sexual abuse delay disclosure of their abuse on average over 20 years, with many delaying disclosure well into their 50s and 60s. This means that most survivors will never have the option of using the civil justice system to cover the decades of costs they incur for their healing. By assigning an arbitrary statute of limitations for child sexual abuse, we are siding with abusers and perpetrators over survivors and making Missouri a sanctuary state for pedophiles. This must end. Second, Senate Bill 590, which we are referring to as Trey's Law. We are referring to it in that way in honor and memory of Trey Carlock. This bill would eliminate the use of nondisclosure agreements and civil settlement agreements for child sexual abuse cases. Nondisclosure agreements are legal mechanisms that were created to protect trade secrets, not trauma secrets. The use of NDAs in child sexual assault cases legally silence survivors. This results in two dangerous and sometimes lethal consequences. First, the very people who hold the truth are legally silenced. Therefore, society remains at risk as bad actors maintain their good public standing and reputation, while a small set of silenced people know that children are at a great risk in their care and/or presence. Second, nondisclosure agreements are an accessory form of abuse for survivors of child sexual abuse. Not only does their forced silence reinforce and escalate the shame and trauma that results from being a victim of this horrific crime, but it also prohibits survivors from healing through one of the most researched and proven modalities, sharing their story. It is important to note that this bill does not force survivors to share their stories. It gives them the choice of if, when, and how they choose to do so. It should be their choice. They should be allowed to heal. They should be allowed to warn the public about predators and predatory institutions. Survivors of child sexual abuse should not be allowed to be legally silenced. I appreciate the committee's consideration of these two important bills. I'm happy to take questions that the committee might have for me, but in the interest of giving these victims and advocates as much time as possible to share their stories, I will also make myself available to the committee outside of the hearing to answer questions that you may have. Thank you.